Okay, done. Okay, my name's Dan. I'm the principal for Visa Solutions. This is Andrew Emmett sitting next to me.
Good morning, all.
Andrew is the Director for Immigration Services, and I would like to thank everyone for making the time. We're running a couple of minutes behind, but as you can imagine, it's been a fairly busy week, and we just had a couple of minor technical difficulties. So a quick recap over what's occurred this week is that we came back from the Easter long weekend, and about midday on Tuesday in Sydney, the Prime Minister announced that there were going to be major changes to the 457 visa program. And in particular, he announced that the 457 visa will be abolished effective from March 2018. However, in the interim, there are going to be a number of narrowing measures to reduce the use of the 457 and restrict its use. And those measures occur at various points in time. So some of them occurred as of the 19th of April, so as of Wednesday. The next change will be the 1st of July. We then have further changes on the 31st of December. And then finally, we see a new system come into place with the abolition of the 457 visa in March 2018. Okay. We've sent out a note to all of our clients and colleagues, and that was it was done to provide a bit of a roadmap about what was going on, and in there we've tried to break it down across the timeline so that everyone knows exactly what's happened immediately, then what the next stage of the changes will be, and then the change after that. And the reason for that is because it's important that we work out what the fact is compared to what the rhetoric is. A lot of the times in politics, what happens is a news press release goes out, the minister makes a new announcement, but actual legislation behind that has not changed. And then what we do is we work out what the legislation says and what it means and its intent when it actually is released. And that might be different to what was released in the press release. And I suspect that this is going to be the case in this instance over the next 12 months. And the reason for that is because there are a load of occupations that have been removed from the list which directly impact on particular sectors. We've been through the list. The oil and gas sector is going to be significantly impacted. The health sector is going to be impacted. There's going to be effects on small and medium enterprises. And that's probably going to be disproportionate to the effect on the larger employers. So all of these issues will have to be dealt with. The government will have to work out how they plan to work around it without having a negative impact on the Australian economy and on Australian businesses as well. Okay. From that, we can probably have through the rest of the webinar just a little bit about some of the issues that we've been asked to deal with. Mm-hmm. So maybe we can run through our FAQs.
Yes.
And then maybe we can talk a little bit about what we expect to happen. We've got to wrap the webinar up around 12 o'clock. Okay. All right. So do you want to run through, Andrew, the FAQs?
Yeah, do you want me to just give an overview of the key structure of the changes first? Do you think that would be useful?
Yeah.
Okay.
Yeah,
all right. So the starting point is really that the Department of Immigration have reduced the number of eligible occupations for 457 visa applications and subsequent permanent resident visa applications at this stage by some 216 occupations. So there are now a number of occupations that have been removed completely from the list, and there is the remaining list has been split into two sections, one which can result in the grant of a 4-year temporary resident visa and gives an ongoing pathway to permanent residency. The other, which will give, in its initial form, only a 2-year temporary resident visa with an option to renew once, and a very much limited pathway to permanent residency. We may have to wait to see how legislation pans out with that, to see what permanent resident visas are for people on that restricted list. So that gives us sort of a background. Mm-hmm. Just as an example of occupations that have come off the list: geophysicist, petroleum engineer, chemical engineer, HR advisor. There are lots of occupations. Where's the list of removed ones gone?
Removed occupations, yeah.
We've got lots of lists in front of us. Biochemist, biotechnologist, driller, environmental health officer. There's some fairly fundamental occupations on this list that have now been removed, and that will make it very difficult for people to make applications for either 457s or permanent residency moving forward.
Andrew, just on that, let's tackle a couple of the issues here. We've had drillers removed from the list, and that's an occupation that's heavily used in the oil and gas sector. So, previously the oil and gas drilling companies would bring in drillers on 457s. The occupation's removed from the list. What do they do now?
Well, in the short term, they can't be bringing drillers in anymore. We've got one chap at the moment who wanted to transfer his existing 457 visa as a driller from his current employer to a new employer. At the moment, we won't even be able to do that. We won't be able to transfer his visa across. So for an existing visa holder in an occupation that's been removed, his visa will run its course until it expires, but it can't then be renewed, and he can't make an application for permanent residency as the proposal stands at the moment. But there may well be changes. The Department of Immigration have flagged that they will look at the occupation lists every 6 months. There will be some industry pushback on the Department of Immigration, and various interested industry groups will jump up and down and say, this is not going to work. We need this particular occupation to be on another list, a different list. We need something else to be put in place. That's what we're expecting to see, hoping to see. But at this stage, if you're a driller, you will need to be looking at other options, maybe a partner visa application, maybe a working holiday visa, but you would need to look at another pathway to be allowed to remain in Australia or to come to Australia if that's your profession.
What about the other one was taken off as maritime professional, not elsewhere classified? We used to use that a lot in the maritime industry for our clients, particularly in the northwest. They've got a vessel coming in. What are they going to do?
We will need to find another pathway for them, maybe another occupation. Examples of that on a barge or a drilling vessel would be the derrick crane operators, the highly specialised crane operators on board a drilling vessel, and maybe we call them ship's officers. We'll need to find another pathway for professions like that, because the vessels can't operate with those without those specialists.
What about in the health sector? We have a number of viewers who are operating in the health sector. Yeah, and we've got a few key occupations that have been taken on the list in that sector as well.
I've gone through and we've got health or allied health professions, biochemist, biotechnologist, clinical coder, some of the dental professionals, hygienist, prosthetist, therapist, exercise physiologist, life scientists, microbiologists, operating theatre technicians. If you're working in a hospital environment and you needed to rely on operating theatre technicians coming in from overseas, that's just been removed from the list.
I've got a question here from Crispin, and it's occupations that remain on the medium-term list. Do they remain unaffected?
For all intents and purposes, yes. Although there will be, there is the proposal from next year onwards, the applications for the employer nomination scheme and the regional sponsored migration scheme, you will need occupation on the medium long-term strategic list. There will be additional occupations available for regional employers using the regional sponsored migration scheme. There's going to be a minimum residence eligibility period of 3 years rather than the current 2 years. The big change is that applicants will need to be under 45 years of age rather than the current 50 years. And we've not yet seen any flagging of possible exemptions from that. Back in the old days, when the age criteria was 45 previously, you could claim exemptions or waivers under almost any criteria that you chose. More recently, we've had specific waiver options, but as the proposals stand, and from what we've seen, they are saying everyone will need to be under 45, and we've not seen anything to say that there will be a waiver option on that.
The other thing about that is the government's flagged that they're going to continue to look at the list, and they'll look at it at least 3 times between now and next year. So it will be from 1 July, it'll be from December, and then it'll be in March as well.
Yes.
So if you are on the medium-term skilled list and you're holding 457, or you want to make application for permanent residency, with the current announcement, I don't think you can feel confident that there are going to be no further changes. It could be that your occupation will be added to, or other occupations may be added to the list as well. But the list is going to continue to change and continue to evolve. I'd be surprised if occupations come back on. If anything, we're probably looking at further narrowing of occupations. And you may well find that some of the occupations will swap between the lists depending on how the government wants to treat a particular occupation in a particular region for a particular industry.
Yeah, there was an article on one of the news websites last night about medical researchers, and the thrust of the article was that this is going to severely impact on Australia's position as a major contributor to worldwide medical research if we can't attract senior medical research professionals. Medical researchers haven't been removed entirely, but they are at the moment on the short-term list, which means that there's only going to be the potential, as it stands, for a 2-year 457 or the 2-year temporary skill shortage visa, as it's going to become, and then no option to apply for permanent residency. The implication of that is it will put people off. We don't get top professionals in the industry, and medical research may then suffer. So, the relevant peak body is already jumping up and down and saying, this isn't going to work for us. This isn't going to work for Australia.
For sure. I'll just unmute Crispin. Crispin, you asked that question. Does that answer your query about what happens to the occupations on the medium-term list? Yes, thank you. Sweet. Okay. All right.
We've had a range of questions through over the last 2 or 3 days, as you perhaps expect. I'm already on a 457 visa. Will this affect my eligibility for permanent residency? Potentially, yes, it will. It depends on the occupation. It depends when your visa will run out. It depends on what list you're currently on. It depends what list you will be on in due course. Certainly, if you've got an option to apply for permanent residency sooner than perhaps you had anticipated, it would be a good idea to do that. Really, anyone who's on a 457 that can still apply for permanent residency now should definitely think about doing that. And if you've got other visa options, for instance, a partner visa, if you're in Australia on a 457 and you're in a relationship with an Australian, that might be a pathway to think about.
So Crispin's just got a follow-up question, and it is a 3-year wait for PR/citizenship already in effect? Current applications, will they be rejected or deferred for the 3rd year? And are they likely to be grandfathering course like on the 457s?
I think that at the moment the 3-year requirement is only going to be coming in it's proposed to come in March next year.
Yeah, Andrew, I think there's a couple of things that have been, during the course of the week, everyone, there's been a number of announcements. The first group of announcements was in relation to the abolishment of the 457, and then some changes to the 116 and the 187. Then the next day, the Prime Minister flagged some changes to citizenship, and he also extended the residency requirement on a permanent visa to 4 years before you can make an application for citizenship. He also announced that there were going to be stronger requirements for Australian values and we're also going to be an English language test, which was going to be applied at an IELTS of 6. Now, that was the second round of changes in terms of strengthening Australian values, but making it more difficult to get Australian citizenship down the track. So that was a separate announcement. The 3 years that Crispin you may be referring to were out of the 457 announcements, where you had to be, or effective from March of next year, you have to be on a version of the 457 for a period of 3 years,
Yes.
rather than the 2 years previously. Is that your understanding?
Yes.
Yep. So that, and will there be grandfathering clauses? Well, good policy usually indicates that they will not adversely, retrospectively affect someone who already holds a 457 visa. But in the context of what's been occurring and the speed and the fact that a lot of it's been done without consultation, I wouldn't rely on the fact that we're getting good policy through. Rather, I think they're looking at politically making the changes as quickly as possible to minimise the negative effects. So grandfathering clauses should normally apply, but in this case, I wouldn't rely on it. The changes will be made quickly, and they may well be made retrospectively.
And just following on from that, any applications for 457 visas or the transfer of a 457 through a nomination that's already been lodged with the Department of Immigration but not yet finalised, and there's a lot of those in the system, bearing in mind that the Department of Immigration has been taking up to 10 or 12 weeks, maybe even a little longer in some cases, to process applications. Any of those applications that have not yet been finalised, if the occupation has been removed from the list, it's now not eligible for a 457, those ongoing applications will be withdrawn, or applicants will be written to and invited to withdraw their applications and a refund of their fees. And if they don't do that, their application will be refused. So sort of related to grandfathering in that it's not happening with existing lodged but not yet finalised applications. Our understanding is that permanent resident visa applications that are already lodged with the Department of Immigration under previous legislation, previous rules, should go through, but even that remains to be seen.
Yeah. All right. Do you want to run through the rest of these FAQs that we've had during the week?
Yeah.
What's the next one?
Next one. We've sort of touched on this. I'm on a 457 visa, but I'm in the process of changing employers. My occupation's available on the short
SSTOL.
SSTOL. These acronyms are wonderful. Can I still get permanent residency after 2 years? Probably not. You may not even be able to change the. If it's on the SSTOL, you'll be able to change the employer, but you won't be able to go on further unless there's another rule change in the meantime. The occupation's been removed. I want to change employers. We've touched on that.
Yeah, that's pretty clear, isn't it? If you're on a 457 and your occupation has been removed, the Department of Immigration will not approve a nomination or a further visa application for you under the 457 strain. So that's quite serious. In those instances, give us a call and talk to one of the team here, because the ramifications of that could be quite disruptive, quite costly, and we want to make sure that we go through your situation in detail.
Yeah. You could have a scenario where someone has been on a 457 for 3 years or so with family here, the kids are settled in school, and if your occupation's been removed completely, you can't renew the 457 and you can't apply for permanent residency. So we will need to be looking at other visa categories that might be appropriate based on the primary visa holder, maybe the partner, making the partner the primary visa applicant, maybe a partner visa sponsored by an Australian citizen or permanent resident. Other visa options are going to come into play there.
Okay, then we've got the 457 visa holder. The nominated occupation has been removed from the list. Can they get PR through 186?
Same question again. Really, at this stage, no, unless there's a change.
Another one is the person has a current 457. It's expiring in 6 months. They don't meet the 2-year requirement due to the change in employment, and the occupation is on the short-term list. How are they going to get PR?
Well, if we're still on the SSTOL, maybe the first thing to do would be to renew the 457. At the end of that period, there should be an option to renew for a further 2 years. And then we would need to look at what new rules come into play, what happens with the occupation lists, what other options are available for the individual.
The next one is pretty clear. If your application's been lodged and has been finalised and you're off the list, you have to withdraw.
Yeah, we've talked about that. Withdraw that, get a refund.
The last one is probably more significant. The businesses rely on a specific occupation, probably a small business, SME of some sort, and that occupation has been removed from the list. How can they sponsor somebody in the future when they genuinely aren't able to find a local Australian? And the example that I'm thinking of is the geophysicist that was removed from the list. You've got a mining exploration company. They're heavily reliant on getting the skills.
Yes.
Somebody from overseas who's done that work in Mongolia or US or somewhere else in the world. And the geophysicist is no longer on the list.
Yeah. Yes, if you have a small specialist company that specifically provides geophysical mapping services, and that's the only type of professionals they need, all of a sudden the business is potentially wiped out if there are no available skilled professionals in Australia. Dan's done in the past a number of labour agreements, which would be the appropriate mechanism. That's negotiated in conjunction with the employer, the unions, the Department of Immigration and other interested parties, so that you're no longer constrained by the restrictive list of occupations that would normally apply to the 457.
Just be careful with labour agreements. They are lengthy, they can be expensive, and you are required to consult with all stakeholders. So if you operate in an industry where there is a strong union element, you are then required to argue your case for 457s and the occupations with the union, which has got implications for industrial relations and a whole range of other issues around the employment relations sphere. So, but we can certainly help with that. We've done lots of that sort of work, but we would need to talk to the companies in detail, and it's a case by case. All right.
I just wanted to jump back in. We're focused mainly on 457s and employer-sponsored permanent residency. There is an equal effect, or potentially an equal effect, on people applying for permanent residency for skilled migration, and maybe for international students who've been studying here and were planning on, applying for a temporary or a permanent resident visa. If your occupation's been removed from the list, those pathways will be closed off. I was working on an application up to last weekend for a client in the United States, getting a skills assessment in a particular occupation. That occupation's now been removed, so I will need to find another pathway for that general skill migration applicant.
Just got a quick clarification from Crispin. And Crispin, I'm not sure whether you can, I've made you able to talk or communicate with us if you're able, if you've got a microphone, but I'm not sure whether you're there or not. Are you able to join the conversation, Crispin? No? Okay. No, that's cool. So he just wanted a clarification. Occupations that are on the MTSOL, generally unaffected. For example, nurses and doctors' nominations, is it business as usual, except for the reduced age limit? And he says, no, his mic doesn't work, so I apologise.
Okay. My view on that is that if the occupation remains on the MSTSOL, then yes, they are fine. We can do a four-year 457, we can do a transfer of a 457, we can still apply for permanent residency.
Correct.
We can still apply for general skill migration.
Correct.
We've still got the same pathways that would apply to a student that's been studying those occupations onshore.
I think what they have to be a little careful of is that they've already flagged that the 457 visa will be abolished in March 2018. So you do have the issue about whether the visa expires before March 2018 or after. And that will determine whether they're applying under the current rules, temporary rules, if we like, or whether they're applying under a new temporary entry scheme that we actually don't know what the rules are at this stage because the legislation hasn't been written.
Yes.
And so I'd just be a little cautious. So yes, the answer to your question, Crispin, is yes, it's business as usual. If you're on the medium-term list, you hold a 457 for your doctors and your nurses, etc. When the new system comes into play, we'll have to look at what the 457 renewals will look like for the new applications for 457s under whatever visa subcategory they call it, because we'll have two streams operating there.
Yes. Business as usual, but with extra caution.
But with extra caution. Yeah, that's right.
And
so
you know, as I say, going back to what I was saying earlier, if you've got options to apply, do so whilst the going is good. It's getting harder as a general rule rather than easier.
Yeah. Okay, when we're getting to the half-hour mark on the webinar, so I didn't really want to go much further. We've got a lot more that we can cover. The issues have been coming up all week. One of the other issues that has come up is the caveats and the concept of what a caveat is. And there are about 59 occupations that are partly restricted, shall we say. They remain on a list of some sort. If those occupations apply to you, the caveat is a new concept as far as I can see with the Department of Immigration. And they're trying to target it so that it operates either in an industry, in a particular subcategory, or in a regional sector of some sort. They're being very particular about how they want to engineer the use of a particular occupation. If you fall into that category with the caveats, please give us a call and let's chat about it one-on-one. Okay.
I'm going to jump in there and just give you an example of one that comes up a lot. Cafe or restaurant managers. The Department of Immigration always had issues with fast food establishments, but they've now specified that a cafe or restaurant manager excludes a position in a limited service restaurant, which encompasses fast food or takeaway establishments, drinking establishments that offer only a limited food services, and limited cafes that encompass coffee shops or mall cafes. So, you know, the Jamaica Blue, those sorts of cafe chains, they're no longer going to be available for a 457 or for permanent residency.
And don't forget the labour agreement for the fast food industry was pulled about 2 weeks ago. So they don't have access to the fast food labour agreement either.
Yeah.
Okay. All right, guys. Everyone, okay, we're gonna wrap it up now. Listen, thank everyone for joining, taking time out. It's lunchtime here in Perth. It's 12:15, so I imagine a lot of you are keen to get to lunch. If you have any questions, give us a call, give myself a call, Andrew, Fiza, Zar, Michelle, Julianne, anyone of the team. And we will, and Liz, don't forget Liz, because she's in Canberra. And we will do our best to get back to you as soon as possible. This webinar will be recorded and it'll be going up on our YouTube site if we've handled that technology correctly. And I'd just like to thank everyone for participating. So,
thanks, guys. Have a good afternoon.
Okay.
And a good weekend.
All
Thank
the best.
You. Bye.